If you're not a US citizen and you own more than $1 million in US stocks, there is a risk that you need to understand. The United States charges estate tax on certain US assets when the owner dies. This applies even if you do not live in the US and never held a US passport. If you personally own shares in US companies, US listed ETFs, or US mutual funds, those are treated as US situs assets. If you die while holding them in your personal name, your beneficiaries and family members may face a tax of up to 40% as an estate tax, and the exemption is only $60,000 US. That means anything above $60,000 can be taxed. If your portfolio is $1 million, most of it is exposed. My name is Shiraz Vaid and I'm the co-founder at Lipitus Wealth. And in this video, I will explain how this US estate tax works for non-US residents, why your beneficiaries could lose up to 40% of their inheritance to US estate tax, and how alternate ownership structures such as a UAE foundation in DIFC or ADGM can reduce this exposure when designed properly. Estate tax in the United States is not based only on citizenship. It can also apply based on where the assets are located. Shares in companies such as Apple, Microsoft, or Tesla are considered located in the United States because the companies are incorporated there. The same applies to most US listed ETFs. If you personally own those shares and you die, the United States may treat them as part of a taxable estate. For US citizens, the exemption is currently very high. For non-US residents, the exemption is only $60,000 US. And that is a critical number. If you hold $1 million US in shares, $940,000 may fall into taxable range. The tax rate can go up to 40%. This is not about income tax on dividends. It's not about the capital gains while you're alive. It's about what happens at death. When death occurs, brokers often freeze the accounts until tax clearance is received. Beneficiaries may need to appoint US representative. There can be delays before the assets are released. If your family depends on liquidity, that delay can create practical problems. At lower level of investments, some investor accepts the risk. But once you cross $1 million in US securities, the number becomes meaningful. If your exposure is multi-million dollars, the potential tax becomes much larger. The exemption does not increase with your portfolio. Many international investors build large positions in the US ETFs because they are efficient and liquid. Over time, the value grows. Often, no one reviews the estate tax position. We focused on asset allocation and performance, and that is normal, but ownership structure is separate from performance. Estate tax applies to assets you personally own at death. If you do not personally own the asset, it may not form part of your personal estate. This is where structure becomes relevant. A structure does not eliminate tax automatically. It changes who legally owns the asset. If a properly formed legal entity owns the shares and you do not own them directly in your personal name, the estate tax analysis can change. Well, the key word here is a proper structure. The structure must be real. It must have legal substance and it must follow the rules of each jurisdiction involved. Well, in Dubai, one of the recognized legal vehicles for long-term estate planning is a UAE foundation that can be established in DIFC or ADGM. A foundation is a separate legal person. It can open brokerage accounts. It can own shares. It continues to exist even if the founder dies. If the foundation opens the brokerage accounts in its own name and purchases the US securities directly, the legal owner of those shares is the foundation. You are not the direct owner. If structured correctly, this can reduce or even eliminate the US estate tax exposure on those assets because the individual did not die owning the US situs property personally. However, this depends on proper implementation. The foundation must generally hold the assets. The shares must not remain in your personal accounts. Legal ownership is what matters. First, the foundation is formed, let's say in DIFC, declared charter and defined beneficiaries. Council members are appointed, governance rules are set out. Then a brokerage account is opened in the foundation's name. Compliance checks are completed and source of fund is documented. After that, the funds are transferred into the foundation's account. The family foundation purchases the US securities directly. From that point, the foundation is the registered owner of those assets. If the founder dies, the foundation continues. There is no personal transfer of US shares at that moment. This changes the estate tax trigger. It also improves continuity. The council can continue managing the portfolio according to the predefined rules. Now, your next question would be, how does the foundation is actually controlled? Setting up a family foundation does not mean that you lose all the influence. Founder can define the governance rules. You can appoint or remove council members under defined conditions and even become a council member yourself. You can then set the distribution guidelines. But the control must be structured. If you design the foundation as something fully revocable and entirely personal in substance, other jurisdictions may question it. Good structure requires coordination with tax advisors in your home country and in Dubai. And when doing these cases, it is not a template implementation. It is done meticulously on a case-by-case basis. Banking here is also important. Not all brokers treat foundation the same way. The documentation must be clear and the compliance must be clean when setting up and operating the foundations. Now, US estate tax is just one layer. There may be also dividend withholding tax on the US shares. There may be tax rules in your home country or the country of domicile. For example, if you're UK domicile, UK inheritance tax may still apply to certain assets. If your beneficiaries are US person, additional US rules may arise. So with that understanding, no structure works in isolation. Residency, domicile, and treaty rules must be reviewed. The timings of these structures also matter. Structures are stronger when implemented before health issues or legal disputes arises, because the intent of doing things is highly relevant in many legal systems. This is why professional coordination is important. So if you hold, let's say, more than $1 million in US securities personally, and you are not a US domiciled person, it is sensible to review your position. In many cases, you do not have to liquidate your existing portfolio to implement a structure. Several brokers allow account level transfer of holdings into a foundation's account, subject to their internal compliance process. This means that the shares can often be moved without triggering a sale, although each broker must be checked individually. And if your net worth is significantly higher and you plan long-term family governance, separating ownership from individual often makes sense. If your exposure is small or temporary, the cost and complexity of a foundation may not be justified. The decision depends on scale, family structure, jurisdictions involved, and long-term plans. And if your portfolio is growing with the market, your structure should evolve as well. Now, if you want our help and would like to explore whether this structure fits your situation, you can request a personalized asset protection plan by clicking the link in description below. That's it for today, and I will see you in the next video.